If we use ranked choice, more people get a voice. It's not a case of I lose if you win. When we find common ground, we can turn this thing around and somehow solve this mess that we are in. There are always more than 2 points of view.
Welcome to Thinking Green. I'm Rana, and I'm here today with Ken Krayeske, who is this year's Green Party candidate for Attorney General. So welcome, Ken.
Hey, Rana, thanks so much for having me on. I really appreciate it.
Well, it should be fun, and I think it's been probably 10 years since you were last on the show.
12, but who's counting?
You are better than I am, apparently.
It was 2010 when I ran for Congress in the 1st Congressional District.
And of course, back then we did things in person a lot more, for better or worse. But, you know, the Zooms, I don't mind them. It's a good way to connect with people who don't live right around the corner.
And it avoids me from having to spend a lot of time and effort driving and gas and admissions. But there's nothing like being in person. You know, Zoom depositions are really tough to do. Zoom court is tough to do, but we're trying to make it work, you know?
Well, we're kind of forced to make it work somehow.
Yes.
So, to me, you're a familiar face, and this year, you know, I was really happy to hear that you were willing and interested in running for Attorney General. But you want to spend a little bit of time just talking about your political background and, you know, your involvement with the Green Party in the past.
Well, I'll give a little primer about who I am for people who don't know me. I was born in Waterbury, Connecticut. I grew up in Watertown, which now when I look back on it, it was a highly segregated community, purposefully developed for the process of and purpose of segregation, economic and racial. I went to Holy Cross High School in Waterbury. I graduated in 1990. And then I studied magazine journalism at Syracuse University and received a Bachelor of Science in Magazine Journalism from Syracuse University in 1994. And I worked as a journalist for a good decade. And before that, because I was writing for the Waterbury Republican American when I was still in high school, they used to pay me $2 an inch to cover high school sports. It was great. I got paid to being a journalist is one of the best jobs in the world. And for those who are interested, the background that I'm using is Indian Cove in Guilford, Connecticut, right next to Mulberry Point and Sachem's Head and Joshua's Cove and Tuttle's Point. And I've spent a lot of time there because my parents had a house there, and I just love it, and it's nice to look at. So, and my office is messy with client information on the walls, so I need a virtual background. So, basically, in 2004, I went to work for Ralph Nader's presidential campaign in Washington, D.C. He hired me to be his national youth coordinator. I'd done a lot of work with youth journalism in Hartford. And on Ralph's campaign, everybody in the national office on 16th and P in DuPont Circle in Washington, D.C., everybody who had any responsibility in the campaign was an attorney. Kevin Zeese, the late great Kevin Zeese, who was his press secretary. I didn't know until then he was an attorney. I don't know if anybody knows Kevin Zeese. He was Cliff Thornton was friends with him because Kevin and Cliff in the 90s were anti-drug war, anti-prohibition fighters together. Cliff actually introduced me to Kevin at one point. And so, you know, Ralph Nader's campaign manager, his press secretary, his field operations, everybody who had any authority in the campaign had a law degree. And it made me say to myself, okay, I have to do this. These are all people who I know and respect. And I was 32 in 2004. And, I tried my hand at freelance writing one more time. And in 2006, I enrolled in Quinnipiac University. I did 2 years there. and then I graduated from the University of Connecticut School of Law in 2010 and became a lawyer in November 2010. I was sworn in as a member of the Connecticut Bar, and then I joined the federal bar in January 2011. Politically speaking, my first year in law school, I ran Cliff Thornton's campaign for governor, and that was a huge eye-opener of the amount of racism that is inherent in the state of Connecticut. We took Cliff to the Bethlehem Fair to walk around and hand out flyers and whatnot, and people called him the N-word. And that was an eye-opener for me. That was, 16, 17 years ago. And obviously we advocated for Cliff to be in the debates. The League of Women Voters and the New London Day had a conflict over whether or not to let him in the debate at the Guard Theater. And then John DeStefano, the former mayor of New Haven, said, I won't join the debate if you have Cliff in the debate. And so they kicked him out. And it's the same story we hear today, Rana. It's so frustrating that we fight this same argument over and over and over again.
It is frustrating, and I've become aware just in the last day of one of the consequences. A person who's a friend of mine, who is not a Green, but is sometimes a Green voter, texted me because Kevin Blacker, who's running for Congress in the 2nd District, was excluded from a debate in Willimantic last week.
Mm-hmm.
And she was trying to clarify with me what his positions are. Now, I'm busy. I don't have time to answer individuals' questions about, our candidates, all of his stands. We don't have a staff. We don't have an office. I'm not going to give people his home phone number. And had he only been in the debate, she could have gone in person or watched it as it was streamed, maybe submitted questions, and then she would be able to form her own opinion on who she should vote for.
Well,
but because of the exclusion, she didn't feel like she had enough info.
And platforming points of view is one of the purposes of debate. But as I think about what the Green Party faces in terms of the two-party system, just to round out my history a little bit. And then in 2010, I ran for Congress as a Green against John Larson. We got 1% of the vote. We preserved the ballot line. We debated John Larson like 4 times. I think I soundly defeated him in multiple debates, but it's not about intellectual prowess. It's not about your ability to be better than somebody in a debate. It's about your ability to raise money and have a network and reach in which you can control various levers of power in order to control ballot access and election management. And I did that run in between. There's a dead time for lawyers between the time when you take the bar and when you're sworn in. And that was like a 90-day window. And we did something very similar then. And I said, I'm only running a 60-day campaign because running a 10-month campaign, you have to be independently wealthy to do that. And I'm not independently wealthy. I'm independently broke.
Which is good because the independently broke are underrepresented in government.
Exactly. So I started practicing law at a small commercial boutique litigation firm in Meriden, and that firm specialized in commercial litigation. I'm not much of a commercial litigator, but the lawyer who trained me, a guy named Houston Putnam Lowry, whose great grandfather or something like that was Israel Putnam, the great visionary and leader. But Israel Putnam also appeared to have been a slaveholder. For people who aren't familiar with the legend of Israel Putnam, down in Voluntown and in Putnam, Connecticut, he's legendary in the eastern part of the state. He's the one who crawled into the wolf's den with a musket and a rope. I don't know if you know this story, Rana.
I don't.
His Israel Putnam's tale of bravery and courage is legend among the colonists. And there's some people who allege that he was the one who said at the Battle of Concord in Lexington, "Don't fire until you see the whites of their eyes." But at the, unfortunately, at the family burial plot in Putnam, Connecticut, there's single Christian name graves, which means that these were people who were held in human bondage in Israel Putnam. Anyways, Houston is a descendant of Mr. Putnam, and Houston trained me how to litigate. And after about 3 years of being a lawyer with him, I started my own law firm on July 1st, 2013. And at this point, I've spent the last 5 years litigating against the Connecticut Department of Correction for rights of prisoners and people who are incarcerated. We've had some really big wins. We filed a class action regarding hepatitis C, and we forced the Connecticut Department of Correction to spend $40 million to test 20,000 people for hepatitis C and cure 1,000 people of the fatal disease. It is curable. Unfortunately, the treatments cost like anywhere between $20,000 and $80,000, and it's very expensive. We represented the woman who gave birth in a toilet in a prison cell at York Correctional Institute, and it's barbaric that in 21st century Connecticut we cage pregnant women. And so we won her some money, and we won the child some money. I've represented the estates of multiple people who have died in the Department of Corrections. I've won a couple of 7-figure settlements. I've lost a couple of cases. You win some, you lose some, it's so. And I have a bunch of cases. Some people have criticized me for talking about my cases, but I know about the Attorney General's office and how it works because I have spent the last 5 years in hand-to-hand intellectual combat with the Office of the Attorney General. I have a really good idea of how it runs, and I have a really good idea of how things can be improved and how things can be bettered.
So what would you say is typical of how the Attorney General's office is being conducted now?
So everybody who knows about the Office of the Attorney General thinks that it is a stepping stone for United States senators and people who want to be in higher office. And also people think that it's an advocate for consumers and citizens. But to me, the Office of the Attorney General is the law firm for the state of Connecticut, and it is charged constitutionally with defending the state of Connecticut when somebody like me sues the state. So let's talk about the case of Cara Tangretti. And Miss Tangretti had one brush with the law in her entire life, and it was a financial crime, and it got her some time behind bars. I did not represent her. She is not my client. And I think her case is a landmark for many reasons. While she was in York, she was raped repeatedly by 3 correctional officers and sexually assaulted by a 4th. There is no consensual sex between COs and prisoners because of the imbalance of power. And so she was raped repeatedly. And she sued after she got out. And the 4 COs who assaulted her were fired and prosecuted and incarcerated, and they had no money. So when she sued the state, she had to sue the supervisors who failed to stop this. And she had the best law firm in Connecticut. She had Koskoff, and Biter. For people who aren't familiar, Koskoff has Chris Maddie, who ran for Attorney General in 2018 against William Tong, has Matt Blumenthal, a state representative, the son of Senator Richard Blumenthal. It has a guy named Bill Bloss, who chaired the Guilford Board of Ed for 20 plus years. And these are top flight plaintiffs' lawyers. It has Antonio Polver, who was first chair in Cara Tangretti's case. And Antonio has won a $36 million judgment against Whiting Forensic in the state of Connecticut for its mistreatment of individuals there. So, Koskoff is a hard-hitting, high-powered plaintiffs law firm with a budget to fight things. and they sued supervisors, and they sued the commissioner of the Connecticut Department of Correction, because I think it seems pretty obvious that it's a systemic problem if 4 COs are able to repeatedly sexually assault an inmate without being found out until she complains, right? There has to be a systemic issue. And she sued. When this happened, she actually, there's a tool called summary judgment, which is in federal court, it's a dangerous weapon against plaintiffs that the state regularly uses. And the state filed summary judgment against Cara Tangredi for the 4 or 5 defendants she had. And one of the defendants survived because the judge in her case said, yeah, I think there's enough to take this to trial. And basically, summary judgment is a tool that allows you to avoid trial and end a case if after discovery, the court says, well, there's no material issues of fact and the defendants are entitled to law as a judgment as a matter of law. So Koskoff and Tangredi appealed to the Second Circuit, where they ran in, or not Koskoff, sorry, Attorney General Tong appealed to the Second Circuit, where they ran into 2 Trump judges and the architecture of the war on terror. After the Twin Towers fell in 2001, George Bush, John Yoo, Attorney General Alberto Gonzalez, Donald Rumsfeld, and all these people waged the war on terror. One of the results was a decision from the John Roberts Supreme Court called Iqbal versus Rumsfeld. Iqbal was a Muslim prisoner in Guantanamo Bay who sued Donald Rumsfeld and said, you are discriminating against me and subjecting me to these horrid conditions simply because I am Muslim. He appears to have been a guy who was subjected to extraordinary rendition and ended up at Guantanamo Bay. And the United States Supreme Court, on a different procedural posture, a motion to dismiss, which is a preliminary motion as opposed to a motion for summary judgment, which is after discovery takes place in federal court. On the preliminary motion to dismiss, the Supreme Court said, Mr. Iqbal cannot proceed to discovery against Mr. Rumsfeld unless he shows Mr. Rumsfeld knew Mr. Iqbal, Mr. Rumsfeld knew the harm that other people were causing Mr. Iqbal, and Mr. Rumsfeld failed to intercede. So Iqbal versus Rumsfeld essentially upended the supervisory liability legal regime that had been in place since Connecticut's Thomas Dodd and United States Supreme Court Justice Robert Jackson prosecuted supervisory liability at Nuremberg. So the architecture of the war on terror basically wiped out Western liberal thought for the last 60 years that said just taking orders isn't an excuse and just making orders isn't an excuse. And so what William Tong did was apply the architecture of the war on terror against a Connecticut citizen. So when Cara Tangredi gets to the Second Circuit, she loses. And the Second Circuit says, well, based on Iqbal versus Rumsfeld, Scott Semple, the commissioner of the Department of Correction, needed to know Ms. Tangredi, needed to know the officers who were raping her, and needed to not intercede with the officers who were raping her. That's an impossible standard to reach. Straight ahead. At that point, there were 15,000 prisoners in the state of Connecticut. For Scott Semple to know every single one of them, is the former commissioner of the Department of Corrections, is impossible. And so there used to be a supervisory liability standard in Connecticut, and there was a 5-point test. And I'll give you an example of why Ms. Tangredi's case is so damaging. You've heard of I've given you some of the cases about the difficulties in healthcare in Connecticut prisons, right? Like my cases are really bad. The hepatitis C thing is the worst. But individuals, I get phone calls every day about people who have suffered grievous harm at the hands of the Connecticut Department of Correction medical system. I only take the cases that are the worst of the worst. One of my cases, a guy named Billy Bennett was at Brooklyn Correctional Institute, and he had problems with his throat. For months, he begged to see an ENT. There used to be this thing called the Utilization Review Committee. People who are familiar with HMOs, health management organizations, understand the utilization review process, which basically serves to function as a bottleneck to prevent people from getting health care. It's a committee of a bunch of doctors that review somebody's file and say, the treating prescribing physician says this guy needs to go see an ENT. He's got a history of alcohol and drug use, which is an accelerant factor for head and neck cancers. And he's got a blockage that, or he's got a problem that hasn't responded to 2 courses of antibiotics. The standard of care says he's got to go see an ENT. The URC says, no, why don't you try him on Claritin? In 2015, Scott Semple had emails by doctors and lawyers telling him the Utilization Review Committee was a roadblock preventing people with risk factors from cancer from getting early diagnosis. Okay, it doesn't say who Billy Bennett is, but it describes Billy Bennett, right? A person who has risk factors, needs early diagnosis of and prevention of cancer. He knew, Scott Semple knew the URC was in 2016, in June of 2016, Billy Bennett starts begging to see the ENT. By January of 2017, Billy Bennett can't breathe anymore. He's got to breathe through his mouth and it whistles. Why? Because he had a stage 4 squamous cell carcinoma of the larynx that had wrapped around his throat and was choking him. And he only got diagnosed with this lymphoma because he was taken to a hospital and they gave him an X-ray and an MRI. And so the URC had denied Billy Bennett care. And what Tangretti says is, even though Scott Semple knew the URC was denying people care, unless Scott Semple knew Billy Bennett personally and didn't act on Billy Bennett's case personally, I can't hold him accountable. I have other emails from Scott Semple showing that Scott Semple understood and knew people were having their teeth pulled instead of filled, which is an 8th Amendment violation of cruel and unusual punishment, to have your teeth pulled instead of cavities filled. So did you investigate how many people, Commissioner Semple, this happened to? No. There's no accountability. So the Tangretti decision creates a landscape in state government where no one can be held accountable in positions of authority. So we'll never be able to, unless we change the law, which I'm not confident that this current makeup of the Supreme Court is going to suddenly overturn Iqbal versus Rumsfeld, or it's going to suddenly overturn any of these other decisions in the sort of case lines that allow us to sue. And the thing is, what this does is it creates immunity for the programs of mass incarceration. And one of my theories in doing this prison healthcare litigation has been that if we lift the lowest rung of the ladder, people who are incarcerated are society's lowest rung of the ladder. If we lift that ladder, and they're also people who are incarcerated are the only ones who have a constitutional right to health care. So if we lift that ladder and expand the contours of what a constitutional right to health care looks like, then it makes it easier for us to do a Medicare for all. It makes it easier for us to begin providing health care to everyone else when we eventually get there. I'm not sure that we're going to get there. We're going to still fight for it. But, I went on a long digression about Tangretti because this is the problem with the Office of the Attorney General, is that where the rubber hits the road in state power, in the state exertion of its use of the monopoly on violence that it maintains, it has the best and worst. And I say the best and worst because they know the law and they use it to protect people who violate the Constitution, rather than the Office of the Attorney General admitting when they're wrong. What the Office of the Attorney General does is say, we will protect constitutional violators at any and all cost. And I'll give you an example. The state of Colorado, the hepatitis C case that I filed, Mumia Abu Jamal in a penitentiary in Pennsylvania was the first person that I'm aware of to litigate to get access to these hepatitis C drugs. They were developed in the early 2000s, and they finally got FDA approval in 2013. And Mumia immediately started suing for access to them. He won. By 2018, I'm in a position to file a class action. We have a plaintiff, we have a defendant, we have a plaintiff who had exhausted all of his administrative remedies. He was made a class representative and so on. But we followed the framework that Massachusetts, Pennsylvania, and other class action plaintiffs had done. So by creating the law, Mumia opened the door for other class action plaintiffs to step in. There was a class in Minnesota. There was how's this? In California, some plaintiffs filed the lawsuit, and within days, the Attorney General's office turned into a settlement posture. In Colorado, within weeks, they filed the class action and the Attorney General turned to a settlement posture. In Connecticut, they moved to dismiss and they objected to class certification. And it wasn't until we actually defeated their motion to dismiss and class certification that they moved into a settlement posture. And even then, they worked really hard to make sure that I didn't make any money on the case. And what that does is send messages to other plaintiffs' lawyers. If you try to mess with us, we're going to bankrupt you. And so to me, when the Attorney General's office does stuff like that, they're protecting executive branch police power at all costs and not concerned about the constitutional violations that occur. Like, to me, an attorney needs to say to his client, you messed up. You're going to have some exposure here. And so, like, I've spent a long time thinking about, why did the state of Colorado and the state of California immediately try to settle with their hepatitis C class action plaintiffs? And why did the state of Connecticut fight? The state of Missouri actually had a similar class action, and they took it all the way to the 8th Circuit and have been fighting there. I'm like, so Connecticut is more like Missouri than Colorado. Everybody thinks that Blumenthal is a great guy. Everybody think that Tong is fighting the Sacklers and he's fighting M&T Bank and he's fighting all of these things. But at the end of the day, Tong uses those consumer actions to obscure the real damage that the Office of the Attorney General does to the people of Connecticut. I'll give you another example. DCF. Who defends DCF in court? DCF doesn't have its own in-house law firm. DCF uses the Office of the Attorney General. So anytime you hear a terrible story about a family being split up by DCF, and then that DCF litigating that, the lawyers who do that are in the Office of the Attorney General. The Child Protection Division of the Attorney General is vicious in the way that it protects DCF's often racist decision-making. And so when you take the sovereign power that the state of Connecticut brings into the litigation arena and the deference that it gets with judges, and you combine that with the precedent like Tangretti and the hundreds of other decisions that really build to sovereign immunity, you have a litigation wrecking ball that destroys lives. And to watch a public relations campaign paper over the real bad decisions that the Office of the Attorney General makes. Like Kara Tangretti's life has been ruined, right? There's no second chance for her. Google her, and what comes up? The fact that she was sexually assaulted and lost. She can't get a job. She lives in fear of running into these cops on the or these COs that, like, how did anything in the state of Connecticut serve her? The state of Connecticut only harmed her. And then when she tried to seek redress of grievances in the federal court system, the state of Connecticut actively fought her rather than being compassionate and saying, hey, we're really sorry that 4 of our employees repeatedly sexually assaulted you. Here, we want to make it right. They said, no, F you, you're going down in flames. And they found 2 Trumpian judges and like, what are we supposed to do? So that's why I'm running. I know that's a long diatribe, but it's like, this is what I deal with on a day-to-day basis as an attorney who litigates against them. And the stories I hear from other attorneys are just as horrendous, if not more so. And so we really need to begin to approach the Office of the Attorney General from a position of protecting the people of Connecticut. And Attorney General Tong will have a press flack that'll respond to these criticisms and say, well, we have a constitutional obligation to zealously defend. But Ms. Tangretti is a citizen of the state of Connecticut. How is your defense of 4 COs who raped and assaulted her help her? It doesn't.
Well, we talk a lot about systemic change too, but this is an atmosphere that kind of tamps down the possibility for systemic change.
Yes. So one of the ideas that I would bring to the Office of the Attorney General is something called billable hours. Anybody who's hired a lawyer to litigate a commercial case knows that lawyers bill in 6-minute increments and you have a litigation budget. If you only have $10,000, you want to file a motion to dismiss and not do any discovery because a deposition costs you $1,500 in costs alone. Forget about the time it takes to prepare for a deposition and actually do the deposition. So you have to be very cost conscious when you have billable hours. My idea would be to implement the system that the state of Oregon has. The state of Oregon has billable hours for every state agency. Every year, a state agency gets a legal budget. The Office of the Attorney General has timekeeping software that tracks the lawyers who are assigned to the cases. So it would create accountability if we knew how much time and money the Office of the Attorney General spent on Ms. Tangretti's case. And then the legislature could say, well, maybe we don't think it's a great idea that you spent this much time and money on harming a person like this. And we could see how much the Office of the AG spends collecting child support versus, going after bad parents or allegedly bad parents who don't fit the white middle class suburban value set that DCF attempts to impose on families. And like, it'd be helpful for us to understand how much time the attorneys who represent the DOT spend on eminent domain. What it does is billable hours creates transparency and accountability. And DOT, the Department of Transportation, having a budget of $3 million for legal services means that we'll see how much they actually spent. Instead, right now, what you have is just a slush fund of a lawyer's office where the state has no accountability. So, and I'm sure that the unions in the Office of the Attorney General's office would be upset about the idea of implementing billable hours, but we'd like to know, what exactly are you spending time on? How are you spending time? And Attorney General Tong will brag, well, I brought in $1 billion for the state of Connecticut over the last 4 years. Well, if he didn't, it would be shocking. You have a huge law firm and you have the sovereign power to litigate against corporations, and you should. And the thing is, he's suing, if you can't win money against Comcast for its awful customer service, you stink. But he's not using the power to go after people like Uber or corporations like Uber that misclassify drivers. The Office of the Attorney General could follow what Javier Becerra, the former Attorney General of California, did, which was file a massive class action and force Uber to stop misclassifying drivers as independent contractors instead of employees. But we're not seeing the Office of the Attorney General do things like that. And that's the kind of stuff that I would do that's different.
And honestly, when you're talking about the billable hours, it seems like it's a message that kind of crosses the typical, I don't want to say party line, but political spectrum that people think of Greens as, because wouldn't it be interesting to have the taxpayer watchdog groups also wanting to see billable hours in the AG office?
It makes sense. And if states are laboratories of democracy, as Justice Holmes suggested, Connecticut ought to try it and see what Oregon does. Oregon didn't even have a hepatitis C class action. Why? As the Oregon Department of Correction was ahead of it. And that's where we need to be. The Attorney General's office sets policy in a backhanded way, because the Office of the Attorney General says to an agency, this is what you can get away with. This is what we'll defend. It creates the floor, and an agency can't go below it. But the floor is not a good floor if an agency is in a position to allow a woman to give birth in a prison cell. It's not a good floor if the agency is allowed to keep somebody in solitary confinement for 25 years. It's not a good floor if the agency is able to build roads designed for speed that kill pedestrians. It's not a good floor if the agency is able to separate families based on a white social worker's perception of how a Black family should be managed. We need the Office of the Attorney General to be more compassionate in the way that it wields power. And it's not right now. It's a stepping stone for William Tong to be governor or United States senator.
So going off of this a little bit, we have about 15 minutes left. The two-party system, so often, you mentioned Cliff Thornton's campaign and how, for racist reasons and minor party reasons both, he was shut out of a lot of opportunities for voters to get to know him. Do you feel like our political system here is making this problem worse because of fewer viewpoints?
It's viewpoint discrimination, and it's really frustrating to email the League of Women Voters and say, why aren't you including Kevin Blacker and Justin Piglino in congressional debates? And the League of Women Voters says, well, that's the system that we have. Well, that's exactly.
And we've been consistent. I think that was something else.
Yeah, well, that's exactly what Susan B. Anthony would have said. Well, that's the system we have, so women don't get the right to vote. Really? And the thing is, it's so tiresome. Ralph Nader was shut out of the presidential debates in 2000. We've been going on this for decades. We've been fighting this. And the thing is, I've been thinking about this a lot. And I've been thinking that it's a battle the Greens aren't going to win. But the problem is the two-party structure is enshrined in statute. Why does the Republican Party get a registrar of voters in New Haven and Hartford when less than 5% of the voters there are registered Republicans? It's crazy. But then you think about it and you're like, wait a second. So there's a structural codification of the two-party system. But one of those parties now has gone all in on fascist authoritarianism. And what are we supposed to do when elections are only valid to one of those parties when they win? If they didn't win, then it was a fraud. If they did win, well, if it was a fraud and it's in our favor, who cares? But the Democratic Party, I think, is ill-equipped, and we need to create institutions that can step in and fill the void left by the Republican Party's drift into hard right-wing authoritarianism.
I have felt for a long time that in New London, and I'm sure it's a similar case in New Haven and perhaps Hartford as well, and some of the other cities, Willimantic, that the Republican Party is so weak that the Green Party, if there were any kind of a level playing field, could be the second party in town.
So problematically, the United States Supreme Court has said creating a level playing field is not an appropriate constitutional justification for public campaign financing. It's about eradicating the appearance of corruption. And so there's no such thing as a level playing field in the current legal scheme that governs party regulation in the United States, which is really frustrating because there isn't a level playing field. Like we are there. There's viewpoint discrimination. Then there's there's journalistic discrimination where the Hartford Courant writes a story about the Attorney General's office and said there's a 3-party race, and they don't mention the third party candidate until the 40th paragraph in a 50-paragraph story. And you're like, how, what's crazy to me, Rana, is Mike DeMoro from the New London Day wrote a story about me the other day and said, I created a moment that was one of the most memorable in Connecticut press history. I mean, is it more memorable than something that happened in 1860? I have no idea, but at least in his imagination, in his mind, and he's been covering sports for 20 years in Connecticut, 25 years. I did something that changed the way press conferences in Connecticut are operated, right? And I forced a discussion, and it created national news. It was on ESPN. It still gets played as one of the top 10 press conference blowups of all time. And I can do that. But then when I run for office as a third party candidate, nobody wants to say my name. But at the same time, ESPN, when they talked about the Jim Calhoun incident in February 2009, refused to identify me. Everybody says I wasn't a journalist. And I'm like, wait a second. I went to Newhouse. I went to one of the premier journalism schools in the country. Like Bob Costas went to the university that I went to. Am I not a journalist? And it feels like the same sort of viewpoint discrimination that happened there happens here. And I've been thinking, all right, so is the only way I'm going to get any attention for my ideas is if I run as a Democrat? And I'm like, well, that would require me to have started in September of last year, because then I got to call everybody in the Democratic Party who's on state, central, and town committees and say, hey, will you give me delegates so that we can win the convention in May? And then I can spend the summer chasing votes and kissing babies. That doesn't serve any purpose.
No, elections have actually gotten ridiculous here. They start way too early. They cost way too much money. And you end up not really knowing what you really need to about the various candidates.
And most people couldn't identify who the Attorney General for the state of Connecticut is. If you go walk on the street in New London, Connecticut and say, do you know who William Tong is? Maybe 1 in 10 people will be able to tell you, right? The information warfare and the Republican dismantling, and it's probably Democratic too, but the lack of civics education in our country that tells people this is your government, this is how it runs, is astonishing. And so we need to fix that. And so we're fighting from an extraordinary disadvantage, an extreme position of unfairness that's baked into this race. So, Jordan Fenster from Hearst wrote a story this week saying, I know I'm going to lose. Well, of course I know I'm going to lose. The system is designed for me not to have a chance. And I do something like this, and I spend an hour with you away from billable time that I need to provide to clients. so that we could have, and this, what is this? This is going to get on public access. So a couple
It's
hundred,
going to go on YouTube too, so people can watch it, but
couple
it's
hundred
not
people
like
will see it.
network TV.
No, and it's not, Dennis House hasn't responded to me about being on his show, and like, but I've been on Dennis's show before to talk about the baseball stadium in Hartford. You know what I'm saying? Like, I can create news. I can cost the state of Connecticut $43 million in settlements. I can force the state of Connecticut to shut down a maximum security prison like Northern because of the amount of money they need to pay for the hepatitis C lawsuit means they have to shut down a prison. I can force them to make an 8-figure policy decision through litigation. But when I run as a candidate, I'm ignored because I'm not running in the structure that's designed to crush people like me.
Well, that Mike DeMoro article did end with a statement, something like, imagine if Ken Krayeske and Kevin Blacker, who's running in the 2nd Congressional District, who can get press, at least in this area. Imagine if they won and we had 2 people in Connecticut in office who cared about the truth. How would we deal with that? And I think there is a kind of a grain of truth in there that people are so unaccustomed to dealing with the idea of having those in office who really care about the truth.
Well, what that means is the inverse is that in order to have political power in Connecticut, you have to have a facility with dishonesty. And so if I have an allegiance to honesty and I have an allegiance to coming about things through the lens of veracity, then I can't obtain political power. Like then that's what I'm saying is like, I don't even know where to start sometimes with the amount of problems that we have in this country. But at the same time, where I think I can start is by creating a conversation and having a conversation and using certain platforms that exist, like the Green Party's Attorney General ballot line, in order to have conversations with people about things like this. Okay, we want accountability. We don't think it's a good idea that the Second Circuit in the United States Supreme Court now fail to recognize the concept of supervisory liability, and they've repealed Nuremberg. You want to make a federal judge bristle? Tell that federal judge that Iqbal versus Rumsfeld means the commandant at Auschwitz can walk into court and say, I didn't know any of the 30,000 Jews who died in my ovens today, so you can't hold me accountable. That's insane. But that's
insane.
And a federal judge will say, Attorney Krayeske, well, that's not really an appropriate comparison. And I'll say, well, you tell me why this is different. You're telling me that Cara Tangretti can't hold Scott Semple accountable for the fact that 4 COs raped her, or 3 COs raped her and 1 sexually assaulted her. You can't tell me that we can't hold Scott Semple accountable for that because he didn't know those COs and he didn't know Cara Tangretti. No, he ran a system that allowed this to happen. And that's what we need to hold people accountable for.
So before we sign off, I do want to share the screen for a minute or a second so people can see where your name is on the ballot. This is the New London ballot. Your name is 9G.
Way in the lower right-hand corner.
Down there. And, I'm not going to talk today or rant today about ballot design, but when people vote, and we vote for those individuals who we want to see in office, we should be voting all around the ballot. It's a lot easier to just do across one row, but that isn't really the best way to go about it. So in New Haven, Ken is on line G, which is the green line, and Justin Paglino is. It's a different combination in every town, but we do have candidates on all those lines, and write-in candidate for governor and lieutenant governor, sometimes on row H, sometimes on I, depending on whether the town has any petitioning candidates or not.
Mm-hmm.
So yeah, all the ballots should be available to put online, to view online within the next couple of days. Right now, the Secretary of State has done from Ansonia through Reading, but they haven't done the end of the alphabet yet. So if you're in Wyndham or Wallingford, or Windsor, you can't see your ballot online yet.
Any
It
of the
should be up
W's, but
soon.
they're getting there, and it'll be up there. And Rana, I want to thank you for your
Yeah.
decades of activism on behalf of the Green Party, and I appreciate that you get up and do this and continue to do this. It's a testament to the strength of the ecological and social justice goals of the Green Party.
Yeah, well, and of course in New London, we have a good group, so it's not a solo effort to maintain it here. And I think part of the role right now is seen as people who are activists who have done great work as part of social justice movements or environmental movements. Some of them we'd like to see in the decision-making roles and not just in the protest roles. So I'm grateful to you for running this year, and hope people look for your name on the ballot. Any last
I'm
one
sorry.
any
I
last 1 minute closure if someone wants
Well,
to?
I just want to say I implore, and I think the audience who is watching this is already going to be predisposed to listening to the ideas that we talk about and proffer here. But I would implore people to circulate this and to, take steps. If not, when you ask me why I run, if not me, then who? If not us, then whom? Right? If we don't do this, then who's going to do it? So we have an obligation. When you know and you don't act, it's worse than not knowing and not acting. And so we have an obligation to do these things. And I take that obligation very seriously. And thank you again so much for doing this, and get out and vote. But beyond voting, you have to be socially active and socially conscious, and get out there and take action. Educate yourself, take steps, and we'll see you on November 9th, because that's when the real work of democracy happens, when the elections are over.
Well, thanks for being coming and chatting with me today. And next week we're going to take a little break from candidates, and our guest will be Kathy Hermes, who's the new publisher of Connecticut Explored magazine. And she'll talk about the magazine as well as the fairly new New London Black Heritage Trail. So we'll see you then, and thank you, Ken.
Thank you, Rana. I appreciate it.
If we use ranked choice, more people get a voice. It's not a case of I lose if you win. When we find common ground, we can turn this thing around and somehow solve this mess that we are in. There are always more than 2 points of view. If you listen, you'll find out that it's true.